Finishing up this section on the unauthorized practice of law, we're going to look at a couple areas that are a little unique and very specific, but ones that you should be aware of for a variety of reasons. The first is administrative agency practice. So, one of the great things about the administrative agency area is that there are a few agencies that do allow for non-attorney advocacy, which means as a paralegal, you could represent clients through the administrative agency hearing level. If this is something you are interested in, you are likely going to look for an attorney who practices Social Security disability, unemployment compensation on the state level. Those are the main areas, or the one where there's the most cases. There are also some other areas. Obviously, you would want to be appropriately trained and experienced before you walked into a hearing representing a client, but these are some of the agencies that do allow it. The reason that administrative agency advocacy by non-attorneys is allowed is basically threefold. One is that these agency processes and hearings are considered to be quasi-judicial. They're like a court, but they're not exactly like a court. They tend to be less formal. They tend to deal more with facts as opposed to legal theories. And so the idea is that you don't necessarily need all the training and education that an attorney needs in order to be able to adequately represent a client through those processes. A second reason it is allowed is that relatively little money is at issue. And because of that, there isn't generally a lot of money from which attorney fees can be taken, which means, which is the third reason, there is a lack of access to these proceedings and to representation through these proceedings. Now, I do think it's important to note that just because in the whole scheme of things, these cases seem to be worth little money and little money for attorney fees, it is going to be extremely important to clients who are in these situations. So we're not minimizing the value of the case to the individuals in front of these agencies by saying that there's relatively little money at issue. So, what agencies allow this, or why can agencies allow this? There is a federal law, and you do not need to know the name or the site of the federal law, but there is a federal law, United States statute, that allows federal agencies to permit non-lawyer practice. It allows them to permit it. It does not require them to permit it. If the agency decides they want to allow non-lawyer practice, then it is up to the agency to set up how that is going to work and what, if any, criteria or requirements need to be met. So some agencies will allow non-attorney advocacy, such as the IRS, but in order to be able to represent a client through the IRS administrative agency level, you have to be a CPA. So there could be situations where there are certain requirements that need to be met, even though they do not need to be an attorney. Other agencies don't have any specific criteria, and some of those listed are National Labor Relations Board, Social Security Administration, Small Business Administration, those types of things. So, as an example, because these are the cases that of which there are many, let's look at Social Security disability cases as an example of this. Obviously, a specific procedure has to be followed. And I will say, if you're interested in these areas, our administrative law course deals specifically with Social Security Administration disability cases, as well as unemployment compensation cases on the state level. So if you are interested in learning more about these areas, that would be a good course for you to take. It does count as one of your paralegal electives. But anyway, there's a specific procedure that must be followed. There's certain steps that have to be met, certain information that the agency has to acquire. If you make it to a hearing level, if the party is not approved for benefits and you end up at the hearing level at the Social Security Administration, an administrative law judge will hear the case. They are called ALJs. Sometimes, depending on the agency, sometimes they're called ALJ, sometimes they're called hearing officer, so the name can change, but they are the role of the judge. They're the ones that control the hearing, take the information, make the decision. The proceeding is generally tape recorded. These hearings are not generally in a courtroom. They are in a room somewhere, frequently at the Social Security office. Everybody sits around a table frequently. You're not dealing with counsel tables and the bench where the judge sits, that type of thing. So they are much more informal. The client would appear, the client's representative would appear. You can sometimes have witnesses depending on the case. So the representative could ask questions of the client, ask questions of the witness, those types of things. Witnesses are sworn in. They are giving testimony under oath. You can offer exhibits, and then a decision is received. If it is an adverse decision at the administrative agency level, and the next level is going to court, then an attorney would have to represent the party. So the non-attorney advocate could only represent the party through the administrative agency process. Now, on the state level, Pennsylvania has a law specifically saying that parties to an adversary proceeding before an agency, a state agency, a Commonwealth agency, must be represented by an attorney at law. So Pennsylvania law is different than the federal law, whereas federal law leaves it up to the individual agencies to decide whether to allow non-attorney advocacy. Pennsylvania has a law specifically stating that it is not allowed. Attorneys have to represent a party. Now, a party can always proceed pro se, represent themselves, but if someone else is representing them, it must be an attorney. So that has been the long-standing law in Pennsylvania. There's been one exception that's been carved out, and this is in unemployment compensation cases. And these exceptions have been carved out through case law. And again, you do not need to know the names of these cases or the case sites, but that information is provided in the notes for you if you are interested in looking it up. And so back in 1987, there was a Pennsylvania Commonwealth case that said under the regulations promulgated by Department of Labor and Industry, which oversees the unemployment compensation area, that these regulations do permit an individual claiming unemployment compensation to be represented by a non-lawyer in an unemployment compensation proceeding. So that is the one area on the state level, on the Commonwealth level, that allows non-attorney advocacy. Not too long ago, there was another case that basically extended that non-attorney advocacy ability to employers. So employers also can be represented by a non-attorney advocate in unemployment compensation cases, and that is the Harkness case that is listed in the materials for you. And a little bit of the reasoning there, just to show you what the court's logic was in coming to this decision, is the idea that this kind of representation is not really the practice of law, because when you are acting as an advocate here, you're more a facilitator rather than a legal practitioner. You're gathering information, you're gathering paperwork, you're providing this information to the hearing officer. You're not necessarily using legal theory and substantive law along the way. There are not trials per se. They're remedial. Minimal amount of money is at stake, although again, always be advised that this amount of money is always very important to the parties. These are people that are out of work through no fault of their own and have lost income, and it usually takes a few months minimum to get to this hearing level, so they may have been without income for quite a while. So even though in the whole scheme of things, it's not a lot of money, it's going to be a lot to the parties involved. And this also is very consistent with other states that do allow non-attorney advocacy for unemployment types of cases. I would argue there is some element of the practice of law in here, but this is, I think, overall a good decision because it does allow both employers and employees access to qualified advocates who may not be attorneys and who can assist them through this process. Obviously, larger employers are going to hire attorneys, but there are a lot of smaller employers out there that may not want to pay for an attorney, may want to hire the paralegal who works with an attorney in handling these cases. So, it's a good decision, I think, overall. So again, if you're interested in doing that kind of advocacy, those are the areas that you would be interested in looking for employment and looking for an attorney who might be willing to train to train you to do that. When I first started practicing, I was working for a legal services program, and the expert in our program on Social Security disability was a paralegal. He had been doing it for 25 years, and he knew more about it than any of the attorneys in the program. And so it definitely is an area where you can really develop an expertise and represent clients through that process. So another area, and we talk about this also, I think, frequently in civil litigation, is the importance of disclosing the fact that you are a paralegal. Because failure to disclose the fact you are a paralegal can result in UPL or in you being requested to take action that would be UPL, and that is obviously something that you want to avoid. So it may sound a little redundant or crazy at times if you have to keep advising people, I'm not an attorney, I'm a paralegal. You will come across people that will think you are an attorney, and you will correct them, and they will still think you are an attorney. You need to always clarify your status. People will know you work for a law firm. They'll make an assumption you're an attorney. You just have to say, I'm a paralegal working with Attorney Smith, and leave it at that. But you always want to appropriately clarify your status if somebody is confused, or if you believe somebody is confused. And sometimes people feel uncomfortable correcting other people. This is an area where you want to make the correction. It protects you, it protects your attorney. Last thing you want to have happen is somebody contact your attorney and be talking about how they were talking to you, they're another attorney in the firm, when you're not an attorney in the firm. So it is something that you want to make sure that the information you're putting out there is accurate, and that you are correcting any misperception. So it does happen. It happened to me when I was in law school, and I was working for an attorney. People would think I was an attorney because I was working there, and you just have to make that correction. Okay. It is completely appropriate to have business cards with your name on them. It is completely appropriate to have your name on letterhead if the firm wants to do that. The main thing is your title also has to be there as well. So it has to be very clear. As we've already talked about, you can send out letters in your own name if the attorney has delegated that to you. You just need to have your title under your name to show that you are in fact a paralegal. So basically, as long as you're not misrepresenting yourself and your status, or as long as you correct anybody else's misperception of your status, you shouldn't have any UPL issues. But it is something that you do want to make sure you make those corrections if necessary. And the last issue is independent paralegals. Sometimes they're called freelance paralegals. This is not a problem as long as the person who's the independent or freelance paralegal is only engaging in this type of work when they are working under the supervision of an attorney. This is basically like a small business owner who is hired by an attorney for a particular task, a particular job, a particular case. So you're still doing legal type of work, but you're still working under the supervision of an attorney. If a paralegal was to basically open their own practice and do things on their own, not under the supervision of an attorney, that clearly is UPL. But if somebody is able to get the experience they want and just kind of pick up part-time, short-term jobs here and there, where they're not necessarily a continuous employee, that is not a problem. That type of independent paralegal or freelance paralegal is not going to be an issue, because you're still going to be working under the supervision of an attorney when you are assisting clients with their cases. So if somebody says they're an independent paralegal, it should raise a red flag, but you need to ask the next question, which is, what does that mean to them? Because if it means I help clients on my own, that would be a problem. If it means I am hired by attorneys to help them with certain types of cases and it's short-term employment, that is not a problem. That would be completely appropriate.